SurePoint Advisors is an investment advisor in Brielle, New Jersey. SurePoint Advisors is registered with the Securities and Exchange Commission. Registration of an investment advisor does not imply any specific level of skill and does not constitute an endorsement of the firm by the Commission.
Welcome to another episode of SurePoint Advisors Financial Roll Call with James Fay. We are 10-8 in service. This is a podcast for law enforcement by law enforcement. I am James Fay. I'm a retired law enforcement officer and now financial advisor with SurePoint Advisors, and I'm focused on helping law enforcement officers make educated financial decisions that will directly affect their retirement. I truly believe that this podcast will help accomplish that. All right. So often is the case when I sit down with my clients, my current law enforcement clients, and they have to make a decision on listing a beneficiary, I always get the question, can I list my minor children as beneficiaries? And although you can list them as beneficiaries, there might be some additional steps that you need to take in order to do that. So I thought what a great episode this would make to educate our listeners and the law enforcement community about naming your minor children as a beneficiary. And who better to educate us on that than our expert estate planning attorney, Michele Clark. So I was able to talk to Michele earlier in the week and ask her this very question about naming your minor children as beneficiaries. Let's take a listen as to what Michele had to say. Welcome to another episode of SurePoint Advisors Financial Roll Call with James Fay. We are 10-8 in service. This is a podcast for law enforcement by law enforcement. All right, I want to welcome back Michele Clark to the podcast here. It's been a few months since we last heard from Michele. For those of you who don't remember Michele, she's an estate planning attorney here with a local law firm in New Jersey. And she's been on several episodes of this podcast, educating our listeners on the various estate planning topics that we spoke about already. So welcome back, Michele.
Thank you, Mr. Fay. Good to see you, as always.
Thank you. So let's get right into this topic today. So a lot of times when I sit down with law enforcement clients of mine, and we're setting up some sort of account that calls for a beneficiary, they often ask if they can name their children as a beneficiary. So I figured what a great episode this would make on the podcast to maybe educate our listeners in and around naming minor children as beneficiaries. So let me start this by asking you, is it a good idea to name a minor child as a beneficiary? And maybe you can just go right into explaining to our listeners what happens when you do name a minor child as a beneficiary.
Sure. So as a parent, many times clients come to me, they want their children to benefit from their estate plan, right? One of the big concerns, of course, if your children are of age and they're mature enough to handle their own finances, you can just go ahead and name them as beneficiaries or contingent beneficiaries. Of course, we run into a problem when the children are minors when we're designating these beneficiaries on these policies, because the idea is that when you're naming somebody who is a minor, and let's say you pass away and your child is a minor, insurance companies will not just hand over $1 million check to your minor child who could be 6 or 8 or 16, it doesn't matter. So if you name a minor child, which you can, you have to also go the next step and is somehow designate somebody or put something in place that protects that minor and allows the insurance company to go ahead and disperse funds in accordance with your wishes. So the answer is yes, you can. You just have to take it a step further and do some extra things to make sure that the minor is protected. Because if you do not do these things that we're going to talk about today, what happens is the insurance company will have no choice but to say, hey, look, this person's a minor. I can't give them money straight out. Now, next thing you know, they're filing an application with the court asking for direction. Hey, right, Judge, what do I do with this money? I can't just hand it over to a minor. And you run the risk in that situation that the court's going to appoint somebody that you necessarily wouldn't. So it's a problem.
Right. Yeah. So it puts the proceeds in the hands of the probate court, right?
Correct.
And this is something that can be obviously figured out beforehand, right?
Absolutely.
So and you talked about a minor, but just let's tell our listeners, what is the age of majority here in New Jersey?
Okay, so for all general intents and purposes, the age of majority is 18. However, when we're talking about uniform, under the Uniform Minors Transfer Act, the age of
Right.
majority is 21. So
Okay.
when we're talking about the overall, when you have a custodial account, they look at it as 21, which is higher than the 18. So for purposes of this conversation, let's talk about, let's assume that anybody over the age of 21 is going to be a minor, technically, okay?
Under the age of 21.
Under 21, yes, sorry.
Right.
Under,
Okay.
yeah.
Right. Okay. It's funny, you just mentioned custodian, right? So,
Yes.
if you do, we open a lot of Roth IRAs here, or even UPMOs, like you said, both either have a custodian or a beneficiary. So maybe you could just explain a little bit about what a custodian is, and if you can list the custodian, is that a way to get around the probate court having to have those proceeds in their hands and make a decision?
Okay, so from a custodial standpoint, the answer is yes, you can name a custodian. A lot of times, if you name a custodian, essentially what happens is if the child is under 21, the custodian will be in charge of the funds. They'll disperse the funds, they'll hold it in trust in a way, and the custodian is therefore in charge. Once the child reaches the age of majority, then the money gets transferred over to the beneficiary as if they would have hit the age of majority at the time of the passing. So the answer is yes, you can do have a custodial appointed. Everything when we talk about custodians, we're talking about in the best interest of the minor. So the custodian has to act in the best interest of the minor, basically. So yes, that is a possibility. Not the only option, but yes, it's a possibility.
Right. And is that similar to naming a guardian?
So a guardian, very similar, yes. See, when we're
Okay.
talking about a guardian, anytime we do estate planning documents for our client, we ask the clients, who would you prefer to be guardians of your children if something should happen to both of you, right? So the guardian is the person who would step up at the time of death, who takes control of the children and presumably of their money, their life, everything. They kind of step into the role of the parent at that point, right? So what we suggest to clients a lot is when they absolutely know, yes, I want this person to be the guardian. This person's financially savvy. I have no doubts about them. Sometimes we have clients reference the guardian in the beneficiary designation. So you can absolutely say to this person as guardian for the benefit of my minor children, right? So that means the insurance company has one specific person or two persons to give the money to that's going to act in the best interest of the minors. So yes, that's a possibility.
Right. Okay. I kind of understand that, I think. That was a great explanation. But let us educate the listeners, because I always thought maybe this was the best way to go, and that's naming a living trust as the beneficiary. So maybe you can explain whether this can be done or not, and if so, how it's done. So basically naming a living trust as a beneficiary and how that works.
So there are two types of living trust. One is a revocable trust, and one is an irrevocable trust. When we're talking about a revocable trust, that's a trust that can be revoked at any time during the person who creates its life, right? Irrevocable, just the opposite, means you can't really change it. I mean, there are laws that say you can, but you need court approval. It's much more difficult to terminate an irrevocable trust. And the idea of the irrevocable trust is that if I create one and then somehow I become incapacitated, I can't then go ahead and try to revoke it when I'm not in the right state of mind mentally. And it also has some tax benefits and things like that. But when we're talking about minors, the answer is yes, you can designate a trust as a beneficiary under the non-probate assets. So basically what you're saying is I want to give the money to the trust, and then the trust, of course, through its own terms, is going to have a trustee appointed, and it's going to have terms for how you want the money given to the child sporadically. So you can say, I want the income to go to my child on a monthly basis, and then at the age of 25, I want 1/3. At the age of 30, I want 1/3 to the child, and at the age of 35, I want the remaining 1/3. So you can formulate trust in any way you want to. Even simpler than that, what a lot of my clients elect to do is what's called a testamentary trust. So we put a testamentary trust in the will that says, in the event any minors are taking under my will, I direct that to go into trust with this person to be the trustee under these specific terms. Then for your non-probate assets, you can designate the trustee named in my last will and testament under Article 5, the person, the trustee to receive the money for the benefit of my minor children. So that's even simpler, because all you need to do is put the testamentary trust in the last will and testament, and what happens, you can then refer to the last will and testament article number, whatever that may be, as the designated person to take. So that's always a really good option, especially when the people know exactly who they want the trustee to be. And typically it coincides, right? So the person who's responsible enough to be your trustee for probate assets under the will are presumably the same people you want and you trust to be the trustee under your non-probate assets. So as simple as, you know, I would like, the designation would say something like, you know, to so-and-so as trustee pursuant to Article 5 of my last will and testament. That's as simple as you get. The living trust, also good alternatives, but what you have to do is you have to actually prepare a trust document, which could be lengthy and could be ongoing changes. The last will and testamentary trust that you're referring to can be very, very simple. You're literally just saying in your last will and testament, you know, anything that goes to a minor shall be held in trust, and you can literally write 3 or 4 provisions if you want to. You can keep it very, you know, in the trustee's discretion as well. So that's, in my mind, that's the easiest option. And a lot of times I feel that's where my clients choose to go with trust.
Yeah, that's a great option, because I think a lot of our clients are looking to structure how their children will get that money, just like you said. You don't want, you know, your 18 or 21-year-old child getting a boatload of money all at once. So that's really what we're looking for, is great information. So listen, once again, a wealth of knowledge you are, Michele. It's great to have you on here. And I think this will certainly answer the questions that I often get from my law enforcement clients, and you know, about listing your child as beneficiary. So I just want to thank you again for taking the time, as always, to educate our listeners and the rest of the law enforcement community here. And I think this is a very important topic, and hopefully, you know, create a call to action, and we'll get some people to, you know, put this stuff in place. That's the ultimate goal. So
absolutely. Well, thank you very much for having me again.
All right, Michele. Thank you.
Bye-bye.
All right, great. As always, Michele is a wealth of knowledge. She really breaks it down, makes it easy for us to understand the various different topics that she speaks about on our podcast episodes. And I want to thank Michele for taking time out of her busy schedule once again to educate us on this important topic of naming your minor children as beneficiaries. So 10-11 prepared a copy. Let's go over a few things that we can take away from this episode. So remember, we asked Michele, is it a good idea to list your children, minor children, as a beneficiary? And she confirmed, right? Yes, you can do it. If your children are still minors, you might need to take additional steps if you choose to name them as your beneficiary. Another important thing that she went over is the age of majority, right? The age of majority here in New Jersey is 21. So your planning has to incorporate knowing that the age of majority and when your children will get all that money could be at 21. So important fact right there that we need to know. The age majority is 21 here in New Jersey. So if you don't list your children directly as beneficiaries, what other avenues do you have to take, right? We talked about that. Michele talked about listing a custodian. And a custodian serves as the guardian of the money and the assets intended for the minor child. And a custodian may make decisions concerning those assets, but remember, it has to be in the best interest of the child, of the minor child. Very important. How about naming a guardian as beneficiary? Remember, if you're not 100% sure about naming your child as the beneficiary, whether it be an insurance policy or a Roth IRA or a uniform transfer to minors account, whatever it might be, you can always name the child's guardian. Remember, when we create a will, and Michele talked about this in previous episodes, it's best practice to indicate who would be the legal guardian of your children if something happened to you. So you can always consider making them, the guardian, the contingent or backup beneficiary. One of the most important ones that I always thought, would work for, naming a child as a beneficiary is to name a living trust as the beneficiary. And then the money can go through the living trust and get to the children, right? So that's just another way to avoid the potential challenges of naming a child as a beneficiary. And Michele did a great job of talking about a revocable trust and an irrevocable trust. And the key benefits to both of these trusts is that they help your heirs or the people that the guardian or the custodian, whoever it is, avoid probate court. And in probate court, there's associated expenses and inconvenience that also naming a trust can avoid as well. So great information from Michele, as always. She did a great job, again, breaking it down, making it easy for us to understand. So if you have any questions about estate planning and you want to get in touch with Michele, by all means, reach out to me here in the office, 732-876-3777, or you can email me. You might find my email on the website, surepointadvisors.com, or in the show notes. All right? So I want to thank Michele again. She's a wealth of knowledge. I'm sure we'll have her on in future episodes for just more information on estate planning. With that, this has been another episode of Short Point Advisors Financial Roll Call with James Fay. We are 10-7 out of service.